We're ready for the next case, BROWER versus County of Volusia. Pull up briefs. How much time would you like to save? Try to save for rebuttal?
I would like to save 3 minutes, Your Honor.
Did you hear the explanation before?
I did, yes, sir.
We'll see how you do with your timekeeping. The other two advocates ended up using all the time.
I'm on notice. I've noticed nobody else has gotten their opportunity for rebuttal, so I'll try to cover the points on my initial presentation. Good morning. May it please the court. My name is Dennis Bear. I represent the appellants in this action, who are a group of citizens selected that were in support of the referendum of the Volusia County Charter that was challenged by the Volusia County government. The focus on this case, I think, needs to start in 1985. At the time, Volusia was one of the first charter governments in the state of Florida, and there were two methods provided by the charter for amendment. One was by a 2/3 vote of the elected officials, the governing body, and the other was by a referendum similar to the one that we have here that has started.
I'd like to start actually with section 16158.3.
Yes, sir.
And what that says is that action to prohibit vehicular traffic on the beach may be taken by the governing body, not the electorate. So let's start with that, and then go to the referendum, which said that before the county could take that type of action, that they have to go through the referendum process before passing such an ordinance. How is that provision not inconsistent with general law?
So I think you have to look at how Volusia County complied with the 161.58, which was enacted in 1985, by putting up to a vote of the electorate. So the charter provisions, section 205.1, was put on a ballot by Volusia County and was voted upon by the voters. So the county came into compliance with 161.58 by a vote of the electorate. So we think that they've set the precedence for this is how we can deal with 161.58. Again, in 1990...
I have a hard time understanding how that relates in any way to a statutory construction issue. I mean, because they could have done it wrong, and if nobody challenged it, it wouldn't matter. I mean, we're looking at the plain language of this statute and determining what it means, and whether somebody followed it correctly or not in the past really doesn't seem very relevant to that.
But then that's why we rely upon the Florida Land Company versus City of Winter Springs, where you had Chapter 163, which is these comprehensive zoning laws of the state of Florida, provides for public hearing, notice, and it provides that a majority of the county commission, or the city commission in that case, could vote to support a zoning referendum or a zoning ordinance. Then after that, the Supreme Court said it was okay for a citizens referendum after the city or commission in that case had acted to override the city commission. So again, you had a statutory scheme set up, same as here.
Here, they can't take such action until they go through the referendum process, right?
That is correct.
So they can't.
Well, they would have the vote, and then it would be subject to ratification in the referendum.
If the charter was amended to say that that beach driving could be prohibited by a majority vote of the county commission, and that passed, and the voters approved that as a charter amendment, what would your position be? Would that conflict with 161.58?
It would. That would be similar to the Lyons decision, where they tried to provide a supermajority, which was in conflict with the Constitution.
What if the charter was amended and the populace approved that said that the board could only prohibit beach driving in areas where it was already allowed by a 4/5 vote of the Board of County Commissioners? Would that conflict?
Our position is 161.58 sets the minimum standards. So the minimum that you have to have is a 2/3 vote. If the county wanted to increase that by an additional supermajority, I think that would be within the county's prerogatives. Because if you look at 161.58, it provides that if the county has enacted a provision, a charter county has enacted provisions prior to 1989, that they could then essentially be preempted from the regulations of the state. So it's consistent with the GAL decision versus Boca Raton.
The language, any such local government shall be authorized by a 3/5 vote of its governing body, you interpret to mean a minimum of 3/5 vote, and that if the charter said 4/5, that would be sufficient. That wouldn't conflict.
Well, I think, but again, the 3/5 is the minimum that is required by the state law. I don't think you could go to a majority, but I think that as long as you have more than 3/5.
Is that what the statute says? Because the statute says shall be authorized by a 3/5 vote. So a 4/5 vote, to me, as I read that, would conflict with that.
I think that you would then have to look at the legislative intent. From our perspective, they're requiring something.
Since when do you look at legislative intent if the statute on its face is clear and unambiguous?
I would think, again, that it was, if we go back and compare with the Florida land case where you had shall be a majority vote of the governing body, and the Supreme Court said that you could have the governing body make a majority vote, and then you could have a referendum afterwards. So again, I think if you look at the history, what the Supreme Court has said was acceptable in the Florida land decision, that the same analysis would apply here. The court below did not address the implied preemption. Our position that this is not an express preemption case. If you look at the Masson versus Aventura case, the red light cases, there the legislature said that local governments cannot pass any traffic regulations under Chapter 316 because that area had been properly regulated by the state of Florida. So that means we have to look at either the implied preemption argument as to whether or not the legislative scheme is so pervasive as to evidence an intent to preempt the area, which is the Sarasota decision versus Browning. Our position is that there are strong public policy reasons to allow the electorate in Volusia County to continue to vote. As of 1989, again, we think that because the charter mechanism was in place, had been adopted by the voters, that there is a strong policy here to allow the voters to continue to be involved with decisions as it regulates beach activity. And I think that's supported by what happened in 1996, when again the county decided to put this issue up to a vote of the electorate as it regulates beach driving. So the question then, if there's not implied preemption, which again is the GAL decision when it comes to beach protection, the 3rd District Court of Appeals said that the state can set the minimum standards, but local governments are free to enact regulations that are more stringent as it comes to protecting coastal resources. The third prong that we would then look at, as defined in the Sarasota versus Browning decision, comes to whether or not there is impermissible conflict between the two. And we think that the history here shows that previously the two could coexist. The state law could coexist with a charter mechanism because the county has elected in those cases to put it to a vote. There's been no overriding decision by the state. There's been no objection by the state as to that process being utilized. So our position is that this has been essentially delegated to the local government, which means we then look to the county charter as to how these decisions would be made. This is not the type of overriding situation that you deal with on elections, and I think what's critical too is if you look at the Sarasota versus Browning decision, which is the only decision that the trial court cited, we're dealing with election law in that case. And the only area that the Supreme Court held was in violation was where the local government enacted a audit provision that was completely different than the audit mechanism that was set up in the state election laws, where they said you can hire an independent audit company with no time frame set on the time that they have to perform their duties to come in and do the audit. So there they set up a completely new mechanism, whereas in our case we're relying upon the charter referendum language that was in effect prior to 1985 to allow us to petition the government for change. So we come back to the point that this is not inconsistent with the prior actions of the appellee. Again, there's been no overriding or overwhelming public policy advance. to deny the citizens the right to vote. And I think that if you look at the decisions, the Sarasota decision, if you look at the the decision in the Winter Park decision, or Winter Springs decision that we talked about earlier, the Florida Supreme Court has consistently stated that you have to look at the public policy that's being advanced by denying us the opportunity to vote on this issue. And we've not heard anything because it wasn't addressed at all by the trial court in this case. So our position is that we are in accordance with past practice and the language of the charter, and that the referendum should go forward. Thank you.
May it please the court. My name is Daniel Eckert, representing the County of Volusia. I begin my argument with when Mr. Baer concluded his argument before the circuit court, when she inquired, doesn't the referendum make the 3/5 vote pointless? And Mr. Baer agreed. Judge Wolf's summarizing the case law in this area has indicated a local action that provides for a different method for doing a particular act than the method directed by law historically has been found to frustrate the purpose and to conflict with state law. So while we have laid out why we think the statute is expressly preemptive.
I'm not following that. Show me where it's expressly, there's an express preemption in that statute. I'd be curious to have you show me where there's even implied preemption.
Well, the previous case law has indicated it is preemptive, but particularly I point out that the language vehicular traffic is prohibited on coastal beaches except where a local government has done the following. So the state has occupied the field, actually has expressly occupied the field of the allowance or disallowance of vehicular traffic. And if that's not, I think that's express.
Trial judge relied upon express preemption in making this decision?
The trial judge found there to be express preemption. The Circuit Court said that the legislature in section 16158.3 specifically addresses and identifies the manner in which local government can prohibit beach driving. The voting requirement is specific and crystal clear, leaving no room for interpretation. That's the court doesn't, the legislature does not have to use words of express preemption. It just has to indicate that by specificity that it is regulating the subject. And I think the trial court found a basis, found express preemption. She then went on in her findings and found what I think is the basis for implied preemption, and then she addressed herself to conflict, and
if there's express preemption, why would you even go through the analysis of implied or conflict preemption?
well,
isn't that inconsistent? If you had express preemption, you make a finding there's express preemption and you move on from there. The fact that she continued to analyze implied and conflict would would seem to be a better argument that she's not finding an express preemption.
Well, this statute expressly preempts, or in our view, alternatively, impliedly preempts the subject of allowance or disallowance of beach driving. And then it delegates to local government the authority to make the decision to later prohibit beach driving, and but it says it has to be done in a particular manner. So, to your point, Your Honor, the method of the conflict preemption that she found, or was on the basis that essentially, I don't think she used these words, but that would frustrate the purpose. It would make the nullity, make a nullity of the local government vote. I think her ruling was consistent with the general the legislature has occupied the field of beach driving, and that's, I think, is a preemption. And then it tells the local government how it may prohibit beach driving, which is by a 3/5 vote of the governing body, specific words, not referendum. And she found that, correctly so, and I understand we're here on de novo review, that by referendum, that would render that portion of the statute a nullity.
Is the difficulty from the county the use of the word before? Is that or is it the county's position that that there could be no referendum at any point in time? Let's assume that the county passed an ordinance and you didn't, and they wanted to have a referendum that looked at that ordinance that had been passed. Is the county's position that that would be inappropriate?
The difficulty for the county is that the referendum requirement precludes the 3/5 vote from taking into effect.
I understand, and that's because of the use of the word before, correct?
Well, I don't think
before they can take that action, that it has to be put to a referendum vote. I'm asking you, let's assume that it didn't say that the county passes an ordinance, and then there's a referendum subsequent to that. Is the county's position that is preempted either expressly and implicitly or by conflict?
The county's position is that would conflict with the method of decision-making that the statute...
Decision-making, I'm giving you a hypothetical. We're not addressing the referendum that uses the word that before they can pass an ordinance, it has to go to a referendum. So I'm changing that on you. Now I'm saying that it doesn't say that the county simply passes an ordinance and then there's a referendum on that ordinance and the people vote in contrary to the referendum of the county commission. Is that prohibited?
Yes, Your Honor.
Why?
Because it makes the prior decision, the 3/5 vote...
subject to the will of the people.
But that's not the way the legislature said that the county was to make a decision in this case. It indicated it by a 3/5 vote. And by the subsequent referendum, you have made the decision of the governing body a nullity.
Isn't that always the case with referendums?
Well, where a referendum is allowed by law, a referendum subjects the action of the legislature or the local governing body to a vote of the people. That's true. But our position is here that the statute does not allow a referendum to be the deciding factor.
Article 8, Section 1G, that obviously provides that charter counties are granted all powers of local self-government not inconsistent with general law. And your argument, as I understand it, is that the proposed charter amendment would be inconsistent with 161.58, correct?
Precisely.
That's what the Florida Supreme Court is more recently calling conflict preemption, correct?
Well, inconsistency can be one of three kinds of preemption. More recently, the court has referred to conflict
It's
as...
a basic conflict. The statute says this, you're trying to do this, if they're different, they conflict. They're
Correct.
not reconcilable. Any other questions? No. Any other arguments?
No, sir. Thank you.
To address the first point made by Counsel Rappley for the county, he talks about the negation of the decision of the governing body, but that's precisely, again, what the process was in 1986 when the elected officials placed this issue on the ballot for the voters to decide whether or not they were going to allow the county to be authorized to allow for beach driving in light of 161.58. So at that time, it would have been rendered a nullity, and we probably wouldn't be sitting here if the voters had turned it down in 1986. So the process back then was not deemed inconsistent, but that it was the vote of the governing body plus the vote of the electorate, which again is what was allowed in the Florida land decision. And what's interesting, if you look at the Florida land decision where, again, you talk...
The issue in the Florida land decision, was it even was there any conflict analysis at all in that decision?
No, it was looking more at the issue of...
Process issue and...
due process and what the rights of for the electorate as it relates to but it wasn't a conflict analysis. But I think that by the fact that the court looked at it, and then if you look at what the legislature did subsequent to the Florida land decision, which was discussed in the Archstone case versus Boca Raton, the legislature said that there could be no referenda allowed for development orders and other decisions related to land management unless there was a local referendum mechanism in place prior to 2011 dealing with land use decisions. So there the legislature recognized the importance of allowing the voters to make decisions on issues like this, but if there was already a mechanism in place that the voters could utilize, that was grandfathered in. Similar to what we have here in 1985, again, we did have the Home Rule Charter provisions that allowed for a referendum by a citizens' initiative. And so at that point, I think if the legislature wanted to state that we were not allowed to do that, they certainly had the opportunity to do so when 161.58 was enacted.
Is the overarching purpose of 161 to limit beach driving in Florida?
It was to limit it, it was to regulate it, and it was to allow, I think, for the local governments to ultimately make that decision, because if the legislature had decided they wanted to eliminate it statewide on lands of the state, then they certainly could have done it. And if you look now what the result is, I think St. Johns County and Volusia County are the only two counties that still allow it on the level that it's allowed. I think the Amelia Island decision allows parking on areas of the beach, and the Amelia Island decision also, I think, defeats part of the county's argument, because there the authorization came by a special act of the legislature after 161.58 was enacted. So there were other ways that they were allowed to regulate or to deal with the issue of beach driving as well as beach parking. So our position is, again...
One way to look at, if the language of the statute's clear, you really don't look at other things, but one of the things you might look at in determining what a statute means is its overarching purpose. It seems sort of strange to me, in light of the overarching purpose. The legislature says we want to stop beach driving. It can't happen in any of these areas. We'll allow it in some areas where it's existed before, and let the county regulate that to some extent. They can't expand it beyond certain parameters, but the governing body can further restrict it. It seems odd if they're trying to stop beach driving that language should be read to say, but the county, if we're going to make it harder, even harder for counties to stop beach driving in areas where it's permitted. We're going to...
I think part of that analysis, you have to look at the other beach management issues in the GAL decision versus Boca Raton, where again the state set minimum standards for dune permitting, dune walkovers, and because the dunes are the area they're trying to protect. They said that we can set the minimum standards and local governments can enact more stringent regulations. Is similar to here. Again, you have the 2/3 vote plus the vote of the citizens. So they've said that that's allowed, and they've also specifically stated that when it comes to determining your actual management plan, that they look to the Home Rule Charter and an approval prior to 1989, but it didn't say that the Home Rule Charter provisions required a two-thirds vote. So I think there's some leeway there if you read the entire statute, that they look at not just the two-thirds vote to authorize or deauthorize, but they also looked at the Home Rule Charter and the mechanisms there for providing beach protection. Thank you.
Thank you both. Court is in recess.